Welcome to the Environmental Law course, dear learner and viewer. Today we are going to discuss the forest laws and policy in independent India. You can rightly recall my previous lecture in continuation of forest laws and policy in colonial India, where we have seen the evolution and development of forest laws and policy right from 1855 to 1927 after the enactment of the Forest Act of 1927, and we have taken note of alongside all the forest policies which have been permeated right from 1865 to 1927, and then we also try to see that how the ambit and scope of the Land Acquisition Act of 1894 and the first colonial India's forest policy in 1894 has resulted into the evolution and development of forest laws and policy in independent India, and we have noted the very fact that what are the basic object and essence of the Forest Act, which is underpinned into the colonial interest of economic generation or economic interest, revenue generation, levying of the taxes and duties, and to treat forests to meet the demands of Indian Railway and the World War First. And we try to impress upon the point that though the forest laws and policy in colonial India happens to have a very comprehensive codification and guideline, but we are very sorry to see that the forest laws and policy in colonial India has not touched upon the ecological imperative. Rather, it tried to see that law in the wake of developmental pursuit by defining the public purposes under the Land Acquisition Act of 1894 and embarked on dam building, irrigation, agriculture, railway, roadways, and various vital sectors of development, and have taken a very myopic perception of the forest conservation and protection under its colonial vision. Therefore, there is a need to see that what was the difference in the forest laws and policy in independent India, and to this end we try to see that India, when it got independence, and then India was having a challenge that the forest, India was having a total forest area of 40.79. Total forest area lies in the hill districts and covers 39% of the geographical total area of India. Looking at the vast tract of land that says that at least 40% of India's land appears to be the forest. This is a kind of a rough figure at the time of the independence, and where we see that out of this 40% area, which covers the geographic area, happens to be the forest, and 40% of this area lies into what we call in the hill areas, and 60% of this area lies into the plain. So, this kind of a inheritance we had on the count of the forest resources in this country. But forest resources in this country, forest coverage in this country, forest geographic area in this country have suffered heavily in pursuits of the development, wherein the Indian planning and policy and its urge to develop as quickly as possible to become self-reliant, certain side tracking of the forest laws and policy happened, and unfortunately the forest cover has been denuded, degraded, and forests have been shaved under the pressure of the population, under the pressure of the industry, under the pressure of grazing, under the pressure of fuel collection, under the pressure of setting fire. There has been a constant and gradual decadence of the forest resources in this country. Then, after 30 years of India's independence and tries with the destiny, it was realized that the forest cover, which was 40%, have come to mere 11%, and some of the figures put to more pessimistic level of 9%, because the 11% of the forest area represent all kind of the green coverages. So, removing all kinds of other herbs and shrubs and tree as in green coverage from the purview of the forest area, it comes to 8 to 9%, and this kind of the figure within 30 years, that means 1947 or 1950 to 1980, a period of 33 years or 30 years have resulted into sizable almost one fourth of the three-fourth area of the forest have been denuded by faulty planning, by short-lived planning, by myopic developmental planning and developmental pursuit by the government as well as the state. Now, we see that in order to come out of this impasse and the myriads of problems which are associated with the national forest policy and goal, then we see that the government was very much engaged with the with a kind of a depression, that how the forest cover, which is now 8 and 9%, or to be said at 11%, which can be raised to a permissible limit, and the permissible limit is that the thumb rule says that 1/3 area must be of the forest coverage. So, taking 33% area as the most desirable and most threshold area, the benchmark, that this much area must be there to be considered as forest, and the forest area being 1/3 area, then the gap between 11 to 33% appears to be 3 times. It is this realization that post-independent India's forest policies and laws have taken and engaged itself to the task of rebuilding the forest resources, which has been severely damaged under the colonial policy of the forest and colonial laws of the forest. Therefore, what we see that there is a large scale diversion of the forest land for resettlement, agriculture, industrialization, population, and other host of activities coming under the developmental perspective. Having realized this thing, that the need for a forest conservation laws in India was badly felt, because the forest cover growth, which was examined in 1990, in 2000 was 0.20%, and in 2000 to 2010 it was measured to be 0.7%. Then we have some kind of the estimate to see that how the forest cover area has grown. And before we see that what happened in the level of the statistics in regard to the increase of the forest cover from this kind of the problematic, we will slightly refer to the major laws which are governing the forest cover in this country, and that is the law which is known as Article 48A and entry 17A of the concurrent list, which was introduced by 42nd constitutional amendment, and this amendment has brought that whatever confidence was reposed by the parliament to the state legislature, because the forest was a state subject under the state list. But in 1976, what the government has realized, that it is reposing the confidence on the state in regard to making of the environmental forest policies and laws, have resulted into a gradual decadence of the forest resources. Therefore, the first thing, that the forest from state list was brought to concurrent list under entry 17 of the concurrent list, and then Article 14(8) was added here, and that space that the state shall endeavor to protect and improve the environment, including the forest and the wildlife of country. Therefore, now the forest was alleviated at the stage of directive principles of state policy. Forest was alleviated to the concurrent list, meaning thereby parliament and a state legislature both can pass the law, but the parliament has tried to see that it has not alienated the state completely, but have taken a share of the state. But parliament wanted to see that the entire legal discourse and the legal development and legislative initiative about the India's forest should go by the concurrent list under Article 47, which elevated the importance of the forest as a directory principle of state policy, which is considered to be fundamental in the governance of the country. Now, in this regard, some discussion regarding the forest policy of 1952 is important, because the 1952 forest policy have not rightly underlined the pitfalls and the perils of the colonial construct of the forest laws and policy. Therefore, 1952 policy as well as the 1884 colonial policy on the forest and first policy of 1864. So, the policies of 1865, policies of 1894, which was a colonial forest policy, and colonial forest policy along with the policy in independent India, that is 1952 policy, both happens to be more or less falling in the same kind of the construct, because the parameters of the debate, the parameters of the discourse in independent India's 1952 forest policy and the forest policy of 1864 and 1894 by the colonial policy have not changed. And that's why there was a need to have this amendment of Article 48A and 17A, and thus the government have been within its legitimate ground to see that the Forest Conservation Act is to be enacted. And in 1980, the government straightway after 1976 constitutional amendment have brought Forest Conservation Act, and this act wanted to regulate upon the de-reservation of the forest and use of the forest land for non-forest purposes, require central government, as it has been envisaged under 17. The essence and the intention of this constitutional amendment was to usurp the power from the state if a state are not abdicating and not completely wiping out the state from the forest policies and laws, but now the central government have taken as the in charge and the cudgels in their hands to see that how the forest land for non-forest purposes are to be diverted. Unless the central government gives a nod and approval, no forest land for non-forest purposes can be converted. Thus, the violation of this provision, which is very cardinal in matters of the protection of India's forest, have been brought within some kind of a violation and criminal offences, and then the delegated legislation in regard to the Forest Conservation Act have also fortified some point in de-reservation of the forest, as well as trying to see the forest land is not to be further denuded and decayed. Therefore, what we see that 1952 policy, forest policy, which happens to be nationalized, but it was having the same colonial hangover, and then this law from 1952, that shows a complete departure from its past, and that departure has happened to regulate the entire forest by de-reservation of the forest, and as well as having a kind of a ban on conversion of the forest land for the non-forest purposes. We have a large number of cases on the point, but we will be coming on that point at a later stage. At this stage, we are straightway going to see that how the introduction of the Forest Conservation Act 1980 has been a very important legislation, and it has applied to whole of India, even whole of India except the Jammu and Kashmir, and it tries to see that enacted for conservation of the forest. So, from Forest Act 1927 does not have any kind of a conservation. So, what conservation was missing from the Indian Forest Act of 1927, and we see that the Supreme Court, in order to prevent environmental degradation and ecological imbalance caused by the deforestation, have expressed displeasure in a very noted case known as Tribhuvan Prakash Narayan versus Union of India and Ambika Quarry Works versus State of Gujarat. Although there are a large number of cases where the Supreme Court have taken a very exception to it. Now let us see that what are the bare act of the Forest Conservation Act 1980, and section 2 talks about that notwithstanding anything contained in any other law. That means that is something very important, that how this law is going to be an overriding legislation among all the environmental law. So it said notwithstanding anything contained in any other law for the time being in force in a state, no, the word no is important. The state government or other authorities shall make, except with the prior approval of the central government, what is contained, that any reserve forest within the meaning of the reserve forest or any portion thereof shall cease to be reserved. This is what is called the twin objective of this act is the de-reservation of forest. Number one, the de-reservation of forest, and try to see the another point is that banning the conversion of the forest land to forest purposes. So this is what is section 2A of the Forest Conservation Act. It envisages that no state government or other authority shall make except with the prior approval of the central government. What? Number one is section 2.1, that de-reservation of the forest, and second point is that no forest land, that any forest land or any portion thereof may be used for non-forest purposes, and then the central government's prior approval has become mandatory under section 2, and this is the gist of this law as it has been contained under section 1, section 2, subclause 1, subclause 2 of the Forest Conservation Act. Having seen this act and the bare perusal, what the explanation says, that what is non-forest purposes. So for avoidance of doubt and leaving nothing to the chance, it means breaking up or clearing any kind of a forest. Number one, breaking up or clearing of any forest land or portion thereof for purpose other than reforestation. So what is meant by non-forest purposes is not left for any kind of a judicial interpretation and leaving nothing to the chance. The explanation has rightly tried to cull out that it means that breaking up or clearing of any forest land or portion thereof for any purposes other than reforestation is considered to be non-forest purposes. So this section is a cardinal section, and this section is said to be the heart and soul of this law of what is known as Forest Conservation Act. And in this reference we see that it requires constitution of advisory committee consisting of such number of persons as it deemed fit to advise the government with regard to approval, grant of approval number 1 under section 2, and any other matter connected with the conservation of forest. So the echo is the conservation of forest conservation, which was missing in Forest Act 1927. And then section 4 talks about power to make rule, wherein the central government may by notification in the official gazette will try to make rule for carrying out the purposes of the act. And what is the purpose? That de-reservation of the forest and forest use and non-forest use. These are two major purposes which has been enshrined into this law, and then this rule should be put before the parliament for its approval. So it's a very small legislation, a very teeny and very juvenile legislation, but it has an overriding effect, but it touches on the cardinal issue of the conservation of the forest. It touches on the issue that any reserve forest for the or any portion thereof shall cease to be reserved, and then it tried to see that no forest land to be used for non-forest purposes, and the constitution of authority to fulfill these twin objectives. Constitution of the authority under section 3 to look at these twin objective of section 2 and try to elaborate the power by delegated legislation. Thus, we see that the core restriction which emerges out of the Forest Conservation Act 1980 appears to be de-reservation of the reserve forest for the sake of reiteration. Again, we are using the same thing, and use of forest land for any non-forest purposes is also prohibited, and leasing of forest land to any private and non-governmental body or clearing naturally grown trees for any purpose except the reforestation. And the explanation tries to also dispel some kind of the misgiving that what non-forest purposes mean, and exception work ancillary to conservation, and it is to be monitored at all the checkpoint and fencing, dams and boundary mark. Thus, we see that the constitution of the advisory committee, which have been constituted under section 3, and it also talks about section 3A and 3B, which have inserted by way of an amendment, and that amendment appears to be on the point that conversion of section 2 is punishable by imprisonment up to 15 days, or if the government or the offences by the government department is said to be liable and there is a lack of due diligence, so they are also punishable. And then there is a penal provision, and there is a sense of a punishment which has been introduced under section 3A and section 3B, that is one of the embargo on the government officer to be callous and indifferent in looking the twin objective of the matters concerning the forest conservation and conversion of the forest land for the non-forest purposes. Thus, we see that the compensatory of afforestation and implementation as defined in chapter 3, para 3.1 of the Forest Conservation Handbook 2004 is also very important, and that amendment and rule of 1988, 81, 2003, 2004, 2014 and 2017 and its corrigenda happens to guide us further in the light of the compensatory afforestation and implementation, because section 2 has already delineated on the aspect of the reforestation. Therefore, it seems very appropriate to look at the compensatory afforestation and implementation as it has been defined, not in the law, but a better definition we find from the Conservation Handbook 2004, and especially attention is drawn to chapter 3, para 3.1 of the Forest Conservation Handbook, and it tries to pull out a more detail of compensatory afforestation and its implementation. Then the core provision and the environmental significance happens to be no de-reservation, no non-forest use, no clearing of the forest without the approval of the central government, and the advisory committee will see that how the approval and the compensatory afforestation are to be done. And we see that this law repudiated the ordinance which was passed earlier, and it also emphasizes the forest conservation and the environmental impact assessment. Now, what happened in the Forest Protection Act under section 2? No state authority can issue, and aim is to prevent forest degeneration and ensure sustainable management. This is the gist of this section 2, and key restriction happens to be cease to be reserved, be used for non-forest purposes, be leased or assigned to non-government entities, be cleared to naturally grown trees, and guideline of in this respect we see that in continuation with the Forest Conservation Act, let's see that how the National Forest Policy after 1855 regulation on the forest, 1865 regulation of policy, and 1894 first policy in the strict sense in the colonial India, and one policy in 1952 in independent India, and how the national policy 1988 tried to see some of the basic ethos which are underpinned under the Forest Conservation Act have taken a further carry out principle, and it sees that the social environmental scrutiny of all the project to include fund for compensatory afforestation, and it also try to mandate mine management plan and appraisal on the grounds of environment impact assessment. In this reference, we have a case of Paddavetai versus State of Tamil Nadu, AIR 2000 Madras 524, wherein it was said the agricultural claim after notification cannot override the reservation of the forest. Then the private, and it also the other case which is dealing on the private forest land in the state power. Here we see that in Maharaja Fateh Singh Rao Zoo Trust versus State of Gujarat, AIR 1999, Gujarat 346, where the Forest Conservation Act was applied even to private forest, and this is something a very notable judgment. And even if it happens to be a private forest, there is a need for the prior central government after the enactment of the Forest Conservation Act 1980. With this, we have some more cases on the point which we left in the beginning, and those cases are very important. The cases pertaining to the Goa Foundation versus State of Goa, this is a case relating to Konkan Railway, and by construction of the Konkan Railway, there was a wide scale violation of the Forest Conservation Act, and the definition of the forest was followed in a broad interpretation as it has been envisaged in T.N. Godavaran versus T.N. Godavaran case versus Union of India, wherein the forest here means to in a broader meaning, and while having any kind of a developmental project to go, the need for a prior approval under the Forest Conservation Act was made mandatory under the Konkan Railway project, and this case is a point on the Konkan Railway. And the other cases, we have the Ambika Quarry Works versus State of Gujarat, which talks about a lease and renewal treated as a fresh lease requiring approval of the central government, and Yashwant Stone Works versus State of UP, where again the lease renewal application under section 2 must be treated as a new application, meaning thereby that 1980 law has its own focus. In other case of Vinay Verma versus then we see that how the section 2 of the Forest Act is being implemented in the right earnest, though it happens to be prospective, it is not going to be retrospective. So any kind of a lease which has been applied in a fresh manner was to be in consonance with the Forest Conservation Act of 1980. In Vinay Verma versus State of Bihar, the same kind of a ruling we find, and in K. Pradeep Kumar versus State of Bihar, where the Forest Conservation Act provision prevail over the mineral concession law, is something very salutary in that respect, and a State of Bihar versus Indian Aluminium Company, where the reserve forests include forest land and the westland. Thus, the cases which coming like Ambika Quarry, Yashwant Stone, Vinay Verma, N.K. Pradeep Kumar in a State of Bihar, vis-a-vis the cases of the Goa Foundation and the definition which has been teleologically defined, the term forest in T.N. Godavaran case is applied in all the litigational strategy, be that natural lovers movement versus State of Kerala, AIR 2000 Kerala 131, that though the act is not retrospective, but the issue of the compensatory afforestation not a precondition before the approval under section 2, and the practical challenges in a dense state reforestation must be done on degraded forest, and it is to be triggered on the basis of any fallout of the developmental project. Having perused these cases which are coming from different jurisdictions, along with the Tribhuban Prakash Narayan versus Union of India, we try to see that how the Forest Conservation Act 1980, along with the Forest Policy of 1988, along with the Compensatory Afforestation and Implementation Program as envisaged under the Forest Conservation Handbook of 2000, have resulted into some kind of radical change, and that radical change can be gauged from the fact which we can see that what was the status of the forest in 1940 1950, and how the entire 40% area of the forest was denuded to 11% and was falling short of 22% of desirable forest policy, and how one-third forest coverage from the independent India and as well as the 3 times requirement of the forest is going to be met. In this connection, it is to be very pleasant to note that after the enactment of the forest conservation law, the impact of the forest conservation law, the impact of the forest conservation law is that there has been a gradual rise of the forest cover growth. And if we look at the Food and Agriculture Organization's estimate of 2010 and 2015, then we find that 20% total area has witnessed the forest cover, and 2015 report also talks about a slight increase of the forest coverage, and by 20 forest survey of 2013 have also remarked that there is an increase of certain areas in the northeast. Thus, we see that there has been a sectoral and state variation, and the decrease has taken place in Andhra Pradesh, in Arunachal Pradesh, Assam, Chhattisgarh, Nagaland and Tripura, all northeastern state, whereas we see that there is an increase in Jharkhand, in Manipur, in Meghalaya, in Mizoram and Odisha. So, some of the northeast state have witnessed decrease, some of the state have witnessed increase of the forest cover, and then we see that India State of Forest Report to 2023 released in December 2024 report, India's forest cover grew to 698,712 square kilometer in 2013 to 715,343 square kilometer in 2023. So, in a decade, it remarked improvement in the forest cover, and the country's carbon sink reached to 30.43 billion tons of CO2 equivalent to adding 2.29 billion tons since 2005. Thus, we see that this forest report is very important to look at that how gradually the India's forest is being expanded, and how what is the net impact of the forest conservation law of 1980 and what has been the impact of forest policy of 1988, which shows a clear departure from its past and have tried to resolve in a better manner that how the India's forests are to be governed. With this, the case law regulating different aspects of the forest, as we have perused some of the cases, and there is a litigational flow of the case law. So, between these lecture, in a short lecture, it is very difficult to look at the entire canvas of the case law, but the gist happens to be the Godawaran case and the Campa principle let down, and that is a very epoch-making event in the sense that the Godawaran series of the cases known as forest conservation cases, which started 1997 and till the life of T.N. Godawaran, we see that how the compensatory afforestation and fund management planning authority has been created in 2016, and that is a very epoch-making judgment what has been done in the Forest Conservation Act 1980, but that law was in fact revitalized by the series of Godawaran cases, and this revitalized version of the Forest Conservation Act 1980 appears in the shape of compensatory afforestation, fund management and planning authority, giving a backup that it is something important now that all developmental project who have going to use the forest land for non-forest purposes, and therefore we see that whatever has been laid down under section 2 of the Forest Conservation Act, we see that any kind of a penalty is to be imposed in violation under section 3A and 3B, but what we notice that some amount of conversion and some amount of developmental activities will be carried out, as we have seen in the case of the Konkan railway project. Such a Memaat project has been created, and it is out of the creation of this project, certain minor changes in the forest land are going to be done. So, to have a backup and a kind of a buffer or a kind of a cushion, that the Compensatory Afforestation Fund Management Planning Authority have taken the shape of law in 2016, and the Comptroller and Auditor General have expressed displeasure that a very hefty amount is being contributed to this fund remains unutilized for the purpose of compensatory afforestation. So, what we can conclude now, that we should look the forest conservation law in the independent India in the context of forest policies of 1952, forest policy of 1988, and Forest Conservation Act of 1980, and then the Compensatory Afforestation Fund Management Act 2016, along with the salutary impact of the T. N. Godavaran cases and series, which has revitalized this law, and we in the independent India can say to a safer extent that these initiatives and endeavors have resulted into the increase of the forest cover in after the enactment of this law. So, forest law and policy independent India is ends with a very happy note of increasing the forest cover. With this, I thank and I wish you a happy learning.